Great. Welcome back for this afternoon's presentation. I am Tamara Piety. I'm professor at the law school, and it is my very great pleasure to be able to introduce my colleague, Professor Marla Mansfield. Professor Mansfield received her BA from Yale, summa cum laude, and her JD with honors from the University of Wyoming. She, before teaching, was an attorney at the Department of the Interior, based in the Rocky Mountain Regional Solicitor's Office. She is an editor of Year in Review for the American Bar Association section on natural resources, energy, and environmental law, writes the Mineral Law newsletter for the Oklahoma Bar Association. She's also been the past chair of the environmental law section for the AALS, and is a trustee of the Rocky Mountain Mineral Law Foundation. Her research interests include environmental, mineral, and energy administrative law. She teaches property, energy law, variety of subjects here at the law school, and has been involved in the NELPI Center, and it's my pleasure to introduce Marla.
Thank you very much, Tamara. Now, the correct title for my talk is A Reexamination of the Temporal Dimension in Property and Takings, not the temporal dimension of time, which I guess would give me a fairly quick speech, if that would be what I was discussing. Well, in my property teaching notebook, there is a very tattered and well-thumbed article that had been photocopied, way before we downloaded things from Westlaw. I photocopied this particular article, and I bring it up every year when I get to adverse possession with my students. Often the students kind of balk at adverse possession. They sit there and go, what? Someone can take my property, just after time goes by? They really think this has just got to be wrong. What about the fox? What about the fox in first possession? What are you doing? Changing all the rules you taught us? I try to explain that after the passage of time, proving who might have been the prior possessor or even the true owner would get difficult. Why? Well, because memories dim and the quote-unquote owner might die and leave fractionated shares. However, as time passes, it becomes more and more easy to prove who the then current possessor is. And that possessor had been using the land. Therefore, in order to have an orderly system of property rights and to have efficiency and administrative ease, well, the party in possession should be treated as the new owner. Well, some students still glare at me. They say, a professor saying this, a law professor. Gotta be some liberal conspiracy. I mean, all law professors are liberals, right? By definition. So I try to assure them that this wasn't the viewpoint of some liberal law professor, but the viewpoint of a rather libertarian, conservative professor who champions private property rights and first possession as the starting point of property law. But he supports the statute of limitations because the statute reduces errors and lowers transaction and administrative costs. Well, who, of course, was this professor? Of course, it's Richard Epstein. And his article in defense of adverse possession showed an awareness of time's ability to transfer and change property rights. But it didn't go far enough. As he states, temporal issues arise with evident urgency in the law of real property. Land itself lasts forever, and the improvements upon it can last for a very long time. The durability of the asset means that no one person can consume it in a lifetime, so that any legal relations with respect to land will of necessity involve a large number of persons over a long period of time. Because of the length of time in which both physical land and human property concepts interact, there needs to be a recognition that the concept of property must evolve as human understanding of the physical land also evolves. This influences the determination of when regulation could effectuate a taking. Now, Richard Epstein, of course, has a different but very, very coherent theory of takings law. That is very, very coherent if his major premises are accepted. Now, among these premises are that possession is the precursor of property rights, and property rights predate law. Law, in turn, is designed to protect private rights from fraud and force. Government operates through consent and incongruity with what a private party could do vis-a-vis another's property. Now, one big problem that I have with this is the idea that I find that prior to law, any right a person might have would truly be only power. Only when you have law do you actually have a right. Therefore, I think Richard Epstein's takings analysis misses a dynamic element in takings and property rights, namely the role of expectations and how these expectations can change through time and thus modify and recast the role of law and property. Now, in order to explain this, there must first be some, and I admit, oversimplified explanations of Professor Epstein's so well thought out theories. One, his idea of possession as the origin of property, and also his view of taking. Next, the speech will look at expectations and law as central to property rights. From here, Epstein's own critique of expectations as being relevant to takings law will be critiqued because he ignored the temporal element of property rights. The change brought about by time in property rights is fueled by practicality and necessity. One way we will look at this is through the example of changing regimes of water law. And then finally, this speech will examine how changing views of necessity influence takings analysis. Okay, where to begin? Well, first, Epstein has long argued that first possession is the predicate for property law. He doesn't argue it as a historical fact, but as a founding predicate for rights that he finds are underneath or undergirding many different legal systems. takes a very definite philosophical stance on the chicken and the egg dilemma. The chicken being property and the egg being law. For him, property comes first. It is property that predates law. Harking to Locke, Professor Epstein adds that labor, be it only the labor of possession, adds to the rationale for granting property rights to this possessor. With property predating law, law exists to protect private property from fraud and force. There is at least some implicit consent in the system. Now, from here, Richard Epstein does guide his definitions of property and government into a very logically cohesive interpretation of Fifth Amendment taking. First, the government's relationship to property of others isn't greater than a private party's right vis-a-vis the property of others, except for the fact that government could take private property for public use with compensation. If there is no public use, the government cannot condemn or take private property. If there is public use, the government must compensate the property owner. From these premises, Professor Epstein draws several conclusions. Now, Shakespeare concluded that a rose by any name would smell as sweet, but for Richard Epstein, a taking by any name is a taking. Hence, a partial taking is a taking. A governmental restriction is similar to a private party obtaining a restrictive covenant. Okay? Therefore, the government should have to pay. There are two exceptions to requiring compensation. The government would not need to compensate when it restricts use if the government is abating a nuisance, and there would be no need to compensate expressly if there is implicit compensation within the regulatory regime. Now, this idea of implicit compensation is familiar to mere mortals who read literature. I don't know how we can read any more than Richard has written, that read some literature by someone else. It would be our average reciprocity of advantage type of analysis. Well, again, we mortals think that there might be a distinction between partial and total taking. And if we use a total taking scenario, we would have a Lucas analysis. If there was a partial taking, then the Supreme Court's Penn Central analysis would be brought into play. This distinction is a fool's errand, according to Professor Epstein, and of course, he is never going to be a court jester, and he is not going to make this mistake. Okay, the beauty and the allure of Richard Epstein's thinking is how it does emanate from a first principle, possession as the origin of property. And it may be natural to a certain extent to recognize labor and a possession as a source of rights, at least natural to reasonable monkeys and reasonable wolves, as Felix Kohn told us. But there is an alternative view of the origin of property rights, which posits that individual action can't give rise to any Hofeldian right. There has to be recognition of the enforceability of the claim by others. Of course, this is Jeremy Bentham and his idea that property and law are born together and die together. Before laws were made, there was no property. Take away laws, and property ceases. Pardon? Oh, okay. Yes, well, Douglas Baird was surprised that you agreed with something. I would have to drop dead of surprise if you agree with what I'm saying. Okay. Bentham also states that expectations are very important. And when he talks of property, he says that the idea of property consists in an established expectation, in the persuasion of being able to draw such or such an advantage from the thing possessed. Now, this expectation can only be the work of law. Okay, if we look at how expectations may trigger new ways of looking at property rights, we probably should add the adjective reasonable before these expectations, if not the more loftier investment backed. But I'll stick with reasonable expectations. Now, I presume, amongst other arguments, that Richard Epstein would say there's some circularity here. And yes, there is circularity. Law and property are entwined in expectations as part of a process of creating property rights. I also think, though, that law and property are entwined in your analysis, Richard. Your model of private property was admittedly, at least in some of your writings, embraced because of the model's ability to create a coherent legal theory. And you do use some ancient law to bolster this choice. And you begin for your coherent view of property by positing an initial presumption of unrestricted rights. From this point, with limited exceptions, only voluntary actions should change property rights. Now, in this discussion, I sometimes contrast private and public, but that's probably the wrong terminology. What we really should be doing is contrasting not private, but some consumptive or exclusionary uses or some consumptive or exclusionary values. We should contrast these with collective values. Why do I not say public and private is the dichotomy? Well, you can't have any public really without individuals, and each individual's benefits and detriments would have to be counted in the public. But there is a difference between the consumptive or exclusionary value or use and collective values, because collective values are very similar to public goods. They benefit everyone in the community. You cannot prevent anyone from getting the benefit, and it is much harder to create public goods, perhaps, than consumptive and exclusionary goods. What role, if any, would private or collective expectations play in property rights? Should they influence whether or not compensation is required if the government asserts a regulation promoting collective values? Well, let's look at two scenarios that Richard Epstein uses to ask whether expectations should enter into a takings calculation. Now, in the first example, one neighbor is generating pollution that migrates to another's land. What if a neighbor of the polluter knows of the pollution and might just think that the pollution is going to continue? What then should we think? Should the neighbor of the polluter be deemed to waive compensation if this knowing neighbor predicts that the pollution would continue so that the neighbor expects continued pollution? The response is obviously not. There is no assumption of risk by the neighbor whose land is being polluted, and the polluter gets no right to continue to pollute. But maybe eventually there will be a right. If enough time passes, the polluter could gain a prescriptive easement on the neighbor's property. A prescriptive right to deposit pollution on the neighbor's property. Okay, the second scenario that he posits is one in which a landowner does not object to a somewhat trifling regulation, maybe a mild setback requirement. In fact, if he or she had objected, compensation wouldn't have been required. But if this regulation allows the landowner to then have to expect additional regulation, this is a dilemma. Okay, the pervasive nature of uncompensated government regulation should or should not lead landowners to expect more regulation. Well, Richard Epstein obviously says, no, this shouldn't work. The pervasive nature of uncompensated government regulation should not lead landowners to expect more regulation. As he states in one of his articles, but suppose now that the first round of regulation clears the path for sustaining the constitutionality of a second, more intrusive regulation. If initial regulation at once anticipates more to come, it is then incorrect for the state to balance only the cost of upholding the initial regulation, which may only minimally affect private interests, for now the government's initial foray increases its ability to enact subsequent more restrictive regulations without violating private expectations. Well, he has a missing element here. He would like compensation, and he believes that the fact of one regulation shouldn't make you expect others. Okay, the missing element in his analysis here, in the second scenario, is time. Presume that the first regulation is a valid regulation justified by public power. Perhaps the amount of the burden on the landowner is within the live and let live level, or maybe there's some implicit compensation. Okay, so you wouldn't need any compensation for the initial regulation. Now, the passage of time, however, with this regulation in place, begins to change perceptions about the physical nature of the property involved. The property changes in three ways. One is how the property looks, two is how the property is used, and three is how this use affects other property. For example, if the regulation was the setback requirement, the public begins to get used to open space between the building and the street. This allows in sunshine and air. All the other property owners and even non-owners in the neighborhood can expect these amenities. Now, if a private prescriptive easement can arise over time, can't collective or public expectations mature in some way, maybe not into an easement, but have some dignity given to them? Now, generally, expectation analysis is done if you're determining if a regulation would take private property. And the determination of whether expectations existed normally focuses in on the exclusionary consumptive user. Cases ask questions like, shouldn't a regulated industry expect regulation? Did the builder of a marina expect to be able to keep people out of the marina? But I posit that expectation analysis can also look at the collective side of the equation. If property values feed collective public needs, then there may be an expectation that these values will be maintained. As Richard Epstein acknowledges, no person was ever allowed to use his or her property without regard to others. There are some impositions that other landowners might create which aren't compensable. Those are the live and let live irritations that arise out of any community setting. There is also the overriding obligation not to harm others through land use. Lateral support is one duty that each property owner owes to other property owners. Also, there is that very fuzzy thing called nuisance, and no one is allowed to maintain a nuisance on their property. As alluded to this morning, Richard Epstein does have a definite definition of nuisance. He defines nuisance as the creation of noxious conditions, discharges, odors, noise, and the like, that starts on the property of one owner and migrates over to the land of another. A very contained definition. But I posit that it's a time-frozen definition tied to old beliefs that you need a spatial relationship between properties, a direct spatial relationship between properties, in order for action on one piece of property to affect properties distant. To me, nuisance is a much more flexible concept. I'm afraid to put this up there, but yes, there it is. The unreasonable use of property that unreasonably interferes with another's use of property. I do look at this definition of nuisance, which does allow for differences as time passes. Properties don't necessarily have to abut each other to be affected by activities on other property. What private or consumptive use of property is or is not a nuisance that unreasonably interferes with other property or collective values does change through time. Swamps once were to be busted and drained. Swamps, now relabeled as wetlands, are valuable providers of ecological services. Necessity and custom mold different responses to land use as the knowledge of ecology increases. Now, the term necessity I'm using here is more broad than in some of Richard Epstein's writings on taking. In talking about people's rights to use the property of another, he does recount the scenario of a boater being able to dock at someone's private dock during a storm. Justification for this intrusion would be necessity, which was tied to saving the life of the boater. And the boater might have to compensate the dock owner. Now, necessity as what I am talking about is more related to Richard Epstein's necessity in his explanation of how and why property rights evolved. He quotes Blackstone at one point, and Blackstone had said, necessity begat property. In more Lockean terms, if the gatherer of acorns had to wait for the consent of all mankind to make the acorns his, the acorn gatherer would have starved. Necessity in today's world is different than in the world of the gatherer. I posit that property rights must and do evolve in response to changing necessities. As an example of this evolutionary pattern in property rights, why don't we look at the evolution of water law? In merry old England, rights to water were linked to ownership of land abutting the water. This was riparian law, and initially in England, each riparian owner had the right to the natural flow of the water, which means you can't remove very much water from the stream. This works fine if your industry is based on the water wheel, and it works fine if you're in an area that doesn't suffer droughts all the time. Well, this law gets brought over the ocean to North America, and, well, industry begins to change. We now have boilers. We have to use and boil water, and it might not go back to the stream. Okay, so water law evolved, and the reasonable use doctrine arose. This said that each riparian owner can make a reasonable use of the water, but every other riparian owner also has a right to reasonable use of the water. So you have to do what you're doing with regard to others. Well, this is not going to be enough modification of traditional riparian law as European settlers move farther and farther into the western parts of the United States. Because even with reasonable use, riparian law allocated water rights to people who own property abutting the stream. And once we get into the more arid areas, sometimes the uses of water are going to be separated from the riparian land. You've got to move water, perhaps to get to the mining claim, so that you can separate the valuable mineral from the rock. So they came up with the idea of prior appropriation. Rights were allocated pursuant to a modified, and it's a modified first possession rule. The first appropriator would have rights to the water provided the water possessor put the water to beneficial use. Beneficial use was a part and parcel of the water right. In time of scarcity, the shortage was allocated to junior users or junior right holders. Now, some states physically straddled more moist areas, and more arid areas. In these states, a blended system arose, combining both riparian and appropriative systems. Now, how these various regimes of water law were applied were essentially to referee private rights. To a large extent, the bare bones of each regime could fit into Richard Epstein's rationale for government intervention because the choice of water law system was designed to maximize the wealth of the citizens. In the 20th century, however, more and more collective values were superimposed on the water resource. In several states, a public trust was recognized, which required a curb on consumptive water use to preserve wildlife or other collective values. In other states, in-stream rights were recognized. And at first glance, in-stream rights seemed totally at variance to the whole appropriation system because you were supposed to divert water and put it to beneficial use. But some of the collective values required the water to remain in the stream. Well, transitions toward incorporating these collective values into the system were not seamless, but these changes have occurred, and most of these changes have not been deemed to be taking of private property interests in pre-existing water rights. For example, in blended water system states, riparian owners were required to register their rights so as to integrate the two systems. In all but one state, which will remain unnamed to protect the innocent, in all but one state, the change was not considered a taking of private riparian rights. Necessity and practicality overrode the reliance on a prior system of allocating property. Similarly, in oil and gas law, even the unnamed state recognized the constitutionality of surface damage laws. Now, these surface damage laws require an oil and gas developer to pay for the reasonable use of the surface estate. And this requirement of payment wasn't deemed to be a taking, even though the oil and gas developer had a pre-existing implied easement to make reasonable use of the surface. So private expectations vis-a-vis other private interests and what can be done on split estate land or with water have changed through time. More generally, expectations about the relationships to various parties and a parcel of land have changed through time. Additionally, public expectations have changed about what should or should not be allowed to take place on lands that are now known to be interrelated with other lands and collective values or public goods. In other words, private development creates newly understood externalities that were not grasped in earlier days. As with the gatherer's dilemma with the acorns, necessity requires property rights to respond. It's this need or the necessity that has provided a subtext for the Supreme Court's jurisprudence on taking. Now, believe me, this jurisprudence is not clear and it is not perfect. However, one thing the Supreme Court has done, which I say is correct, is recognizing the role of expectations in takings and property law. How precisely do expectations factor into the Supreme Court's precedent? Well, as currently exposited, the Supreme Court recognizes takings are of two kinds. They are partial takings and, total takings, that there are two types of takings. With the Penn Central balancing test, it's very obvious that expectations do come into play. The test expressly considers interference with at least the private party's reasonable expectations. But these expectations are going to be balanced with the public purpose being forwarded by the regulation, as well as financial impact on the regulated. Therefore, you do have a flexible ad hoc response to partial takings. The greater the impact on core communal values, the more economic impact on the regulated can be endured. The Supreme Court, in the Lucas case, posited a second analysis if regulation removes all value from the private interest. In such rare circumstances where regulation removes all value from the private interest, then compensation is going to be required. That is, it's going to be required unless the act being prohibited also was prohibited or was not a part of the private property right because of background principles of law. Background principles of property law include the prohibition against creating nuisances, the customary rights of public, and the public trust doctrine. They gain definition, the background principles gain definition through the public's expectation. Now, because land lasts forever, the temporal dimension in property must recognize not only private efficiency and expectations, but also the expectations that have arisen because of the public interest in property. They change. They may tip the balance in a new direction, just as Richard Epstein acknowledged that time passing could tip the balance in favor of an adverse possessor over an original or prior possessor. Richard Epstein's seductive taking analysis, however, does not adequately account for change in knowledge and ethics. Thank you. Come get me. Oh, then thank you. Okay, good.
you know, because then another possibility.
Mm-hmm.
So raise the value no more. Or does that end? No, because it turns out in the case of the Bible, that more.
Mm-hmm.
The value no more. In fact, you go to a legal case, that is that the obligation obligation on one, you have to go to one spot where the review will do that as well. So the question in all of these cases, whether or not you create equal, some cases, of course, you do, you overfly the and then you never had possession of the land and actually so the part of the document never made it. Or you say yes, it was, but aircraft that effectively designed around the first war, give us a but you said the mistake, I think, it's $120 in every single instance. But you want to sort of do something like the landmark preservation. There were a set of expectations. Airlines, they were transferable. They were protected against aliens, right? And Justice Brennan comes along and the only certain all the stuff goes up to Brennan. Allowing them to appropriate by designation, but it still remains possible. Right to road response, if somebody is coming and saying, you would like white hair on our public street, they're going to use the definition of give you something for the definition. So the question is this. So anybody who's ever worked in New York knows that the landmark preservation was some element of terror. There's a way in which we manage to drive away. It's a threat operation for God to take. And it's not a joke. I mean, it's a very serious kind of social problem. Short landscape. Now, I happen to agree with what would be valued but the Seahawk case is a step. So what it does is it basically follows the business that, so we can buy this stuff if we want to at a recognized market, or we can just designate. Well, why would you ever want to give a government? So it happens to be something that happens. How is it destroyed? Because the only way we can get on this calculation is whether or not the public is before the payment you're going to get on it the way. How do we know this? Because every regime when they've acted, number of cases. Nobody ever wants to. And if in fact you have that as a kind of effect, do we need to go to this conversation mechanism? What is average reciprocity of humanity? Takes it so that it's good the conversation. But in the point that you're talking about, where all new distribution taxes local voters vote out the local representatives. See a huge amount of social wars in those countries. So put two things back into the pot. Put an optimization the way that then we add in a public choice where it is that government is responsible. That's the nature of the decision that we disagree on. Come on, that we agree on the war right? Mm-hmm. We agree on unitization. If we on the oversight. So the battle is now over landmark preservation, so the zoning and upland designation. Are we confident that our regime is better than the one that I proposed, which says, you know, we think?
There is more in this world, Horatio, than Pareto optimism.
And may I ask
What
what it is?
it is perhaps human survival. Well, it is, but it is harder perhaps to put a dollar and cents on it. Now, if there had been less wetland destruction, in Louisiana, would Katrina have had less of an impact on New Orleans? Of course, there also was the Mr. Go Canal. There's lots of different things.
I think you could say that the major destroyer of the national environment.
Initially under the Swamp Buster law. Yeah.